Okay, ladies and gentlemen, first of all, I'm going to call the closed General Purposes Committee meeting to order and recess it until after the special council meeting. So I will call to order the special council meeting. First of all, we need a motion to allow Councilors Day and Hobbs to come into the meeting remotely. May I have that motion? Moved and seconded. Discussion, all those in favor, opposed, carried. All right, so we'll call the one item we've got on the agenda, the cancellation of business license issued to Nagoya Trading Limited, doing business as Tokyo Beauty. So I will call our staff forward. Councilor Rao. Just a minute. Sorry.
Go on. I have to declare that I could have a perceived conflict of interest because I'm a project consultant of the Remedios and Company.
All right.
So I don't want to be seen as having a conflict, so I have to excuse myself from the meeting.
Okay, thank you. And also, I just want to say, I assume you gentlemen are here for Tokyo Beauty. Am I good? I just want to give you a little bit of a heads up that we have a document that says your oral submission. We have received a very large volume of materials on the matter, and so I'm going to ask you to somewhat abbreviate that oral submission. Okay, so I'll give you a bit of time to think about it. Okay, so we have Mark Corrado, and this is our lawyer, Don Howison.
Yes, Your Worship and members of council, my name is Don Howison. Last name is spelled H-O-W-I-E-S-O-N. I'll be assisting your Director of Community Bylaws and Licensing and the City Solicitor with this matter. Thank you.
Okay, there's no need to stand up. Well, you can if you want. Don't have.
Thank you.
Okay, Mark?
To Your Worship and to Council, I would like to begin a presentation before we get into the report. Many of you know me already, but for the purpose of legal counsel here and for others, I'll do a brief introduction of myself. My name is Mark Corrado. I'm the Director of Community Bylaws and Licensing with the City of Richmond. Within the Business License Department, I direct 7 operational or frontline inspectors and 3 administrative staff. The Business License Department has a twofold mandate. 1, to administer business licensing and regulations, and 2, to enforce the City of Richmond's bylaws in relation to businesses. Just as a background, in the 3rd quarter of this year, the Business License Department directly administered and regulated over 17,000 business licenses. There are also over a dozen business-related bylaws that the department enforces. But germane today really is the Business License Bylaw 7,360. When it comes to enforcement, our business license inspectors individually lead and conduct the vast majority of investigations. When a contravention of a provision of the bylaw is found, a frontline business inspector makes the decision to enforce. However, major cases that entail involvement of internal and external departments, agencies, the potential for legal proceedings, such as a Supreme Court or long-form prosecution. Those matters typically involve me, and when it comes to reaching out towards external legal, it requires approval of myself or the city solicitor to proceed. When it comes to cases where there's increased risk to the public or complexity, the business license director will assume conduct of that investigation And this is infrequent, but really we weigh the fact that the public may be at risk, or the city could be at risk from a reputational standpoint. And again, there's a reasonable possibility that this could result in a suspension or a cancellation hearing. Today's proceedings have all those aforementioned factors. Just some background is important to note. I currently have an RCMP enhanced security clearance, and I previously held a top secret level clearance for over 12 years. My need for a top secret clearance began in 2007 when I was a national security civilian investigator. I have held at a minimum an RCMP enhanced security clearance for over 19 years. This clearance enables me on a case-by-case basis to share information from closed source databases, including police databases, on a need and right to know basis with other law enforcement agencies and different levels of government. To begin, just as a backgrounder, the enforcement of the business license related bylaws can take multiple forms, but they're generally graduated in nature in how they're applied. To review, our first step and our most often chosen step is that of education. This is usually applied, however, when there's reasonable grounds to assume a lack of prior knowledge of the bylaw by the subject of the complaint, that there was no prior history of any bylaw violations, and that there's a relatively minor risk to the public. From there can be the issuance of warning tickets, where there is a relatively minor investigation but reasonable grounds to assume the subject had prior knowledge of the bylaw or was willfully blind to that bylaw. Warnings are only given in circumstances where the subject of the complaint, again, had no prior history. Tickets and fines, however, are awarded when there is a prior history of a minor bylaw violation. From there, we can proceed to long-form prosecution, where there is a major investigation and prior history of tickets that have, and there really hasn't been any deterrence in terms of continued violations of the bylaw. Long-form prosecutions, however, occur in provincial court, and they are under the Offences Act, which is provincial legislation. The next step along the way are suspension and cancellation hearings, and those are under the authority of the community charter. Here we find a prior history or repeated history of violations, a serious risk to the public that warrants a suspension or cancellation of that business. So now I'd like to turn attention, council's attention please, to tab 1 of the binder in front of you. We'll henceforth refer to this binder as the special counsel package. And for the clerk, we'll mark this as Exhibit 1. And as noted in tab 1 of this binder, I am the author of the report that is before council today with respect to Nagoya Trading Limited, doing business as Tokyo Beauty, in respect to its operations at 4151 Hazelbridge Way, Unit 3660, Richmond, BC. To begin with the report, there are 3 recommendations: that the business license issued to Nagoya Trading Limited, doing business as Tokyo Beauty, in respect to its operations at 4151 Hazelbridge Way, Unit 360, be cancelled. That council adopt as its reasons for attached in Appendix A of this report, titled Cancellation of the Business License Issued to Nagoya Trading Limited, from the Director of Community Bylaws and Licensing, as council's written reasons for the cancellation of the business license contemplated by recommendation 1 of this report. And the third recommendation, that council resolved to issue supplemental written reasons at a later date to supplement its reasons for the cancellation of the business license contemplated by recommendation 1 of this report as a result of the affidavit evidence and or evidence in the form of oral testimony of the representative of Health Canada that was presented at the hearing in the matter. I'll address that affidavit following my highlighting of some contents within the staff report.
We have read the staff report. Okay, so please proceed accordingly.
To clarify for the record, we are discussing a business that's, their trade name is Nagoya Trading Limited. Nagoya Trading Limited has 3 locations in Richmond. And I'll provide a brief overview again of some of the contents of this report that reference those locations. To begin, those locations are referenced in CNCL 61. There's one location on 8,191 Westminster Way, owned by Nagoya Trading. I'll reference that as the Westminster location henceforth. And I'll end in the culmination of our investigation that references a Nagoya Trading Company located at 151 Hazelbridge Way. That information is located on CNCL 60. I first became aware of food and drug-related violations involving the Westminster location on September 12, 2023, when the City Director of Corporate Communications, who's here today, Clay Adams, Corporate Communications Marketing, contacted me regarding 2 media articles that were released on September 11th from the Vancouver Sun and the Richmond News. The Richmond News article carried the headline and subheading, "Products seized from Richmond store could pose serious health risks." Health Canada raided Tokyo Beauty on Westminster Highway with one product containing an unauthorized opioid. Following this news, I convened an investigative team within the Business License Department that included Business License Inspector Supervisor Victor Duart, as well as Business License Inspector Kashmiro Chahal. Prior to joining the City of Richmond, Inspector Chahal worked with the Canadian Food Inspection Agency, or CFIA, as a food inspector.
I think you should leap to the bottom as to the conclusions for that. Unless they're taking issue with how the inspections were done, we don't need to hear about them. They're in the report.
So Inspector Chahal contacted Ian Kluchnik of Health Canada, who is the supervisor of health product compliance, on September 14th, 2023, for further information to the ongoing investigation and any prior investigations into Tokyo Beauty. On September 15th, 2023, Supervisor Kluchnik responded to Inspector Chahal and made the City Business License Department aware of 2 preceding health advisories that we had not known of. And I'd like to begin by examining these health advisories, by the way, can be found on CNCL 102 and CNCL 12. A brief description, that is. And then I'd like to an in-depth look at CNCL 79. For a deeper analysis. This advisory noted the sale of 9 unauthorized health products that were for sale at the Westminster location. And that this advisory was stark and directed the public to return these products to their local pharmacy for proper disposal. And the advisory noted one product in particular that was quite dangerous. This product was known as Bilbao Nang Gold A, also known as Pabron Gold A granules. And it said that this product contains an opioid, and it was referred to as dihydrocodeine phosphate. On CNCL 81, there's some important health warnings associated with this product. I'm going to read this warning in full, as I think it is germane to today's proceedings. Dihydrocodeine phosphate is a controlled substance regulated under the Controlled Drugs and Substances Act and is similar to the opioid codeine. Although codeine is approved in Canada, Health Canada has not authorized any products containing dihydrocodeine. Dihydrocodeine tablets are approved in certain countries for the relief of severe chronic pain or as cough suppressants. Common adverse reactions include dizziness, headache, vertigo, visual disturbances, confusion, euphoria, nausea, and constipation. As with all opioids, use of dihydrocodeine may lead to drug dependence, i.e. addiction. Dihydrocodeine may cause slowed or stopped breathing, which can lead to severe drowsiness, unconsciousness, and death due to opioid overdose. People with other medical conditions, including but not limited to those that affect the lungs, liver, or kidneys, may be at higher risk of overdose. Children are more susceptible to overdose due to their smaller size. Dihydrocodeine should not be used by those who are pregnant or breastfeeding, or by those with an allergy to dihydrocodeine. Using dihydrocodeine with other central nervous system depressants, such as alcohol, sleeping pill, etc., may worsen its effects. In cases of overdose, naloxone can temporarily reverse the effects of dihydrocodeine. It needs to be re-emphasized the serious risk that this product presented to children, youth, and adults for addiction and overdose. At the same time, one should not lose sight of the other serious health risk contraindications that were there. That is, mixing this product with common substances such as alcohol or other common over-the-counter drugs, or even someone that may have had a common pre-existing health condition. In short, Schedule I substances under the Controlled and Drugs and Substances Act have no business being sold over the counter. I would like to also draw Council's attention to other products that were found in this health advisory, other than this opioid-related product, because they also contain could have adverse health effects. But more importantly, I'd like to establish a disturbing pattern of disregard for the Food and Drug Act and food and drug regulations. On CNCL 80, we see the product Santin Beauty Eye Contact, which contains a substance called neostigmine methyl sulfate, which carries the following side effects as noted on CNCL 82. Neostigmine.
Mr. Corrado, we're going to be here all night at this rate. I'm asking you to summarize. We have your report. I want you to draw our attention to what are the salient details so that we can make a decision on the situation.
To begin, to conclude, then, neostigmine carries with it many adverse side effects, including potential blindness. What the key point here is critically, this same product, Santin Beauty Eye Contact, was seized more than 2 years earlier by Health Canada from the same Westminster location and posted on the second health advisory on March 31st, 2021, beginning with the 5th item, and it can be found on CNCL 86. This same pattern of recidivism can be found on other unauthorized products, such as the Kobayashi Ibon Eye Wash. This was mentioned on CNCL 86. And this contains a potentially harmful product, aminocapraic acid. This health warning can be found associated with that on CNCL 87. And I will note that this product was again found at the Westminster location, but 2 years prior, during the second health advisory, this product was also found on CNCL 90, dated to February 15th, 2019. Again, I'm just demonstrating there's been a repeated pattern from 2019 to 2014 of getting caught and having the very same product appear. 2024, sorry. Following the September 11th news media article involving the Westminster location, I'd like to draw Council's attention to the curious timing of a business license change application for all 3 Tokyo Beauty current locations, as noted in the report CNCL, page CNCL 8 and 9, beginning with paragraph 2. You can find the documentation there. The documentation for the application for Westminster is also shown on CNCL 28 and 29. This license application was signed by Charlene Zhu, whose title is listed as Coordination Manager and Corporate Contact. All 3 locations have, however, consistently been owned by Mr. Zhao Zhu. The prior names for these locations were JCPA Tokyo Beauty, located at 4151 Hazelbridge Way, JCPA International Market, located at 8191 Westminster Way, and JCPA International Market, located on number 3 Road. An outstanding sign and plumbing inspection, however, delayed the implementation of one of these licenses, that for the Westminster location, and also our ongoing investigation of that location delayed our processing of that application. To that point, the Westminster location received a suspension hearing letter on November 2nd, 2023. As you may recall, the suspension hearing occurred on November 14th, 2023. At that hearing, the coordination manager, Charlene Zhu, spoke as a delegate for the company and noted that corrective actions were taken following the Health Canada third advisory. At the 11:15 mark of her presentation at the hearing, she stated, quote, "We have rectified the errors in the 5 non-compliant products, which account for a tiny proportion of our overall inventory." This statement here should be examined further. 1, there is no acknowledgement of the serious risk that this, quote, tiny proportion of products pose to the public. Moreover, Mrs. Zhu, in her presentation, did not acknowledge the repeated pattern of violations across multiple health advisories across multiple years. Lastly, and most importantly, she claimed that these errors were rectified. In short, based on this statement, one would assume that the same product would no longer be available for sale. It should be noted that Mrs. Zhu remains as a key corporate contact for the Hazelbridge and Westminster locations, according to our records. At that hearing, as you may recall, Council resolved the following: that the business license for Nagoya Trading Limited, doing business as Tokyo Beauty, operating from 8191 Westminster Way, Unit 120, Richmond, BC, be suspended for a period of 90 days. Given Mrs. Zhu's emphatic presentation on November 14th, 2023 at the hearing, and claims of having taken corrective actions, and the considerable amount of time that the business license enforcement staff, city staff in general, and council expended on this business, it came as a deep disappointment to staff that once again, Health Canada would find wrongdoing, this time at the 4151 Hazelbridge Way, Unit 3660 location. Less than 4 months later, on March 8th, from that hearing on 2023, Health Canada issued their 4th advisory for the Hazelbridge location. This can be found on CNCL 71. I'd kindly ask Council to turn its attention to this key advisory. I'd like to note the 9th product on the list on CNCL 72. It is again Pabron Gold A cold medication, which again contains dihydrocodeine phosphate and includes the same dire health warnings, disclaimers, and strict protocols for disposal as the 3rd advisory. Again, please note the resurfacing of another ingredient, aminocaproic acid, found in the 2 products being sold at the Hazelbridge location. These products were Santin Santé Beauty Eye Moon Care and Hadalabo Pearl Barley Face Wash. If you recall earlier in my presentation, aminocapric acid, and xanthan products were seized by Health Canada from Westminster locations on March 31st, 2021, as listed in CNCL 86. I'd like to turn your attention back to CNCL 101 for the commencement of the investigation into Nagoya trading, this time at the Hazelbridge location. 3 days following the March 8th Health Canada advisory, one of our inspector teams contacted, Inspector Chahal contacted Health Canada Supervisor Ian Kluchnik. The purpose of this outreach was to obtain more information regarding Health Canada about potential ongoing investigations, and we were concerned with a key point here of deconfliction. This is an investigative term for clarifying roles, mandates, information and evidence, and action steps when different law enforcement agencies are investigating the same subject. To this end, Inspector Chahal and I met in person with Regional Manager of Inspectorate of Health Canada, Dennis Shelley, on August 29th, 2024, at Suite 400, 4595 Canada Way, Burnaby. Both City and Health Canada staff met virtually on September 8th, 2024 this year. At this meeting were representatives of Health Canada, including Mr. Shelley, Mr. Kluchnik, and Linda Ng, Senior Compliance Officer of Health Canada. From the city was Anthony Arachi Capuccinello, General Manager of Law and Community Safety, External Legal Counsel Donald Howson, Inspector Chahal, and me. This meeting was productive as it clarified roles and mandates between respective law enforcement agencies. We reviewed the contents of the open source information and health advisories, as well as shed light on the specific contraventions of the Food and Drugs Act and Food and Drugs regulations regarding various Nagoya trading locations. Most importantly, it was confirmed that it was the city's business license department who had the lead in matters dealing with potential suspension or cancellation of the business license. Following this meeting, on October 23rd, 2024, staff hand-delivered a proposed cancellation of business letter to Nagoya Trading Limited for the Hazelbridge location. For the purposes of this hearing, this letter is marked as, it can be found in CNCL 104, and it was to inform Mr. Zhao Zhu of today's hearing and the right to be heard if he so chose. In advance of today's proceedings, staff received a sworn affidavit from Health Canada. That can be found on tab 4. And this sworn affidavit is again from Ms. Lena Ng, Senior Compliance Officer from Health Canada. And that can be marked as Exhibit B. Let's briefly go through that affidavit. To begin, it should be noted that this affidavit doesn't really provide too much more information than what can be gleaned from the health advisories. It does, however, contain an error. It's shown in paragraph 4 of that affidavit. It states from, and this is Ms. Ng, identified 4 imported products being offered for sale by Tokyo Beauty. Of course, as shown in the table found in paragraph 7, there were actually 5 products that were seized. We've subsequently clarified that error with Ms. Ng and the the solicitor with Ministry of Justice. Just to highlight certain things that are in this affidavit that aren't in the health advisories, there are the specific references of the contravention of the Foods and Drug Act and the Food and Drugs Regulations. That is, under Section 9, subsection 1 of the Food and Drugs Act, the sale of a drug in a manner that is false, misleading, or deceptive, or is likely to create an erroneous impression regarding its character, value, quantity, composition, merit, or safety. We have the section C 01A0041 of the Food and Drug Regulation that deals with the import of a drug without an establishment license. Another section of 14, sale of a drug in dosage form that does not have a drug identification number, i.e. an unapproved drug. and another section that says import of a prescription drug by an unauthorized person. A full description of these sections of the Food and Drug Act can be found in tab 6, and the Food and Drug Regulations sections can be found in the following tab, in tab 7. Just to conclude, when weighing the evidence from the 4th health advisory, as well as those 3 preceding health advisories, and finally, the failure of corrective actions that were to be taken by Nagoya Trading Company prior to the latest serious violation, I must come to the conclusion that a cancellation hearing is warranted and not a suspension. First and foremost, the public was put at risk in a way that is simply intolerable. Customers and the community at large must be assured that various levels of government will do their level best to ensure the products they purchase are legal and will not put them in harm's way. Customers should not be put at risk for purchasing a product that claims to treat one ailment but exposes them to the risk of a far greater one. It is also imperative that when serious violations occur and enforcement action is taken, there is an understanding that there will be a cessation of subsequent violations. Sadly, Nagoya Trading did not grasp the message of deterrence that was sent by the first suspension, and thus an escalation enforcement action is warranted to protect the community and the integrity of our bylaws. I place very little stock in the rhetoric from this company when they advocate that they won't do it again. And yet they have a almost a 5-year track record of repeated violations. That concludes my presentation.
Are there any questions? Councillor Heed.
Yes, just for clarification, either from Mr. Cratter or Council Hawson, with respect to your term 7 health advisories, how did you differentiate that from 7 violations under Health Canada's, whether it's the Food and Drug Act or the CDSA?
Through your worship to Councillor Heed, I referenced there were 5 advisories and there were 4 basic violations, 1 under the Food and Drug Act and 3 under the Food and Drug Regulations. And there were multiple products listed in these advisories. One particular advisory, the latest advisory, the 5th advisory issued on March 27th, 2024, is a clarification advisory. It was done so in regards to skin lightening products because that was a disturbing trend that they found. So some of these advisories list the products and the health warnings that are there. Others go into greater detail when they see a trend that is appears to be happening, i.e. with eye drops that can cause blindness or skin lightening products that can cause serious health effects.
All right.
And, no, just a couple more, just clarification. How many offenses under the Controlled Drugs and Substances Act, or I'm calling them offenses, but given the regulations, how many are we looking at? Are we looking at, because you talked about 2 of them.
Through your worship to Councillor Heed, there were 2 instances where there was a product, the same product, sold by, under the name Pabron egg cold medication or gold egg granules. That contained dihydrocodeine phosphate. Again, this product is listed as a scheduled substance under the Controlled Drug and Substances Act. That product was seized twice. And it was seized most recently in relation on February 27th by Inspector Ng, and that was highlighted in the 4th Health Canada advisory on March 8th. And that product was previously seized again at the Westminster location in September of 2023. There's a 4-month gap between when this product is seized.
My last question, Mayor. So this company has been in existence in various forms from 2019 to 2024. There was a time where they changed all three names. The consistent part of this is the proprietor was the director of every single one of those companies from 2019 to 2024. That did not change, although their names and the incorporated data did change.
Through your worship to Councillor Heed, we have record back to 2017, and that is correct that it was the same ownership, the owner-director, Mr. Zhaozu.
Thank you.
Councillor Wolf.
Thank you, Your Worship. A couple clarification questions as well. Is the Westminster store the main store? Okay, and then,
Through your worship, may I just, I'll answer, there are 3 locations in Richmond and there are multiple locations across the Lower Mainland. There isn't a particular main store.
okay, that I use that term because I saw it in one of the correspondence here that they referred to that as the main store. Would it be acceptable to think that what products would be carried in one store would also be the same in the other stores?
Through your worship to Councillor Wolf, that's entirely possible.
Okay, and then when either Health Canada or your own staff located something that wasn't supposed to be in one of the stores, would we then, or would have Health Canada gone then to check the other stores, or not necessarily?
Through your worship to Councillor Wolf, Health Canada conducts inspections at one location. There would be advisories that are sent to the company outlining the contraventions that are associated with this product and the serious health consequences that could arise from that. And one would assume that those products would have been removed from the other location. However, I have no evidence of that.
And then, thank you. My final question, through your worship, is there a level of protection for staff, like in these places? Like if they're like, not just the people who come in, purchase it and take it and use the products, but just being in the presence of opioids at work or having trials. I think some makeup stands have trials, and so you're just exposed to more of it in the air. Is there not like WorkSafe BC issues in regards to that?
Through your worship to Councillor Wolf, I'm unaware of any WorkSafe BC investigations, and I'm not aware of the health and safety protocols associated with the company in terms of handling materials such as that contain opioids, or the fact that those things may go missing.
All right, thank you.
Councillor Glanders.
Thank you, Your Worship. Thanks for going over everything again. I have a couple of clarification questions as well. When you mentioned to Councillor Wolf that there's multiple stores across the Lower Mainland, do we happen to know if we only picked up the Health Canada seizures in Richmond because that was our focus? Do we know if there's been seizures in other cities?
Through your worship to Councillor Glanders, our focus has been in Richmond, but I understand that there was a previous warning advisory associated with the Burnaby location.
We know of one in Burnaby. We don't know of any others, but we haven't done extensive research into that.
Okay, so we heard about some.
All right.
In Canada, I have a couple questions. In Canada, our rules around codeine in a pharmacy, for example, is we have to ask the pharmacist, and it's their discretion. It's not available just to be taken off the counter. Is that right?
Through your worship to Councillor Glanders, it's a controlled substance, so you would need a license to sell that product. I'm not aware of it being over the counter in a retail establishment.
Yeah, and then at Tokyo Beauty, though, it was just on the shelves?
Through your worship to Councillor Glanders, this is a product that was seized by Health Canada. I'm not sure of whether it was seized from the shelf, but it was readily available for purchase without a prescription.
That's what I mean. There wasn't a pharmacy, and okay. And then just one last question, just to clarify for me about the locations, because I got a little bit confused. In September of 2023, when that story came about the seizure, that was at the Westminster location.
Through your worship to Councillor Glanders, that is correct.
And then we suspended the license at the Hazelbridge location or at the Westminster location?
Through your worship to Councillor Glanders, the The first seizure occurred in September, and that was at the Westminster location. Following from that, council chose to suspend that license in November for the Westminster location. And then 4 months later, some of the same products were found at the new location, which is the Hazelbridge location. And that is the location that we're dealing with at today's hearing.
All right. All right, I'll ask the people acting for Tokyo Beauty. Do you have any questions for this gentleman? No. Okay, that's fine. So everything in this Appendix A is accurate. Is that correct?
Through your worship, to the best of my knowledge, everything in this binder is accurate and truthful.
All right, and you're using this affidavit, you're entering this affidavit as part of your submission, right?
Through your worship, that is correct.
Okay, so shouldn't we mark that as an exhibit, Exhibit 2?
Through your worship, that is correct. Exhibit 2 would be helpful, yes.
Yes, yes, your worship.
Okay. Is there anything else we need to mark?
To your worship, the initial staff report would be suitably marked as Exhibit 1.
Well, if we're marking that,
It's already
if we're
done.
using numbers, the initial staff report would be Exhibit 1.
Yeah,
And the affidavit would be Exhibit 2, your worship.
all right.
That's correct.
Your worship, if I might, also the correction, just the email exchange that includes the identification of the error.
Oh, well, Mr. Corrado has referred to that, and I think it's fairly self-evident. I mean, it needed to be verified, but it's pretty obvious what had happened. All right, so we'll excuse you, gentlemen, and we'll ask the parties acting for Tokyo Beauty to come forward. Okay, so please identify yourself.
Push a button. Go ahead. Hi, Mr. Mayor, councilors, staff, council. I'm Lawrence Hung, barrister and solicitor at Remedios.
Lawrence,
Lawrence Hung, H-U-N-G.
okay?
Here's Matthew Remedios, article student, and Han Wan Bu, article student. We're legal counsel for Nagoya Trading Ltd., which is doing business as Tokyo Beauty. So I'm going to turn it over to Matthew for our oral submissions. I'd ask you to hold questions if you have any until the end, but I assume that's what we're doing anyways.
Mr. Mayor, members of the council, my name is Matthew Remedios. I'm an article student at the firm Remedios & Company. Today I'll be presenting the submissions of Tokyo Beauty in response to the proposed cancellation of its business license for its store located at 3660-4151 Hazelbridge Way, otherwise known as the Aberdeen store and herein referred to as such. This hearing addresses the recommendation made by Mr. Mark Corrado, and we are here to provide Tokyo Beauty's position and demonstrate why the license cancellation is both disproportionate and unwarranted under the circumstances. Additionally, we have provided each member of council with physical copies of our submissions and evidence, including detailed documentation of Tokyo Beauty's compliance measures, training protocols, and communication with regulatory authorities. These materials offer a comprehensive account of the steps taken by Tokyo Beauty to address past concerns and demonstrate its commitment to regulatory adherence. Tokyo Beauty regrets the past issues identified by Health Canada. While these incidents were unfortunate, they have since been fully addressed. Tokyo Beauty has made extraordinary efforts to ensure full compliance with all applicable regulations. These efforts underscore sincere commitment to maintaining the highest regulatory standards and ensuring the safety and well-being of its customers. Our submission will cover Tokyo Beauty's factual background, the steps taken to ensure compliance, the company's economic and social contributions, and its ongoing cooperation with all applicable regulatory authorities. We will also highlight the lack of inspection by the city to evaluate the current compliance and propose alternatives to license cancellation that align with the principles of fairness and rehabilitation.
Now, I'm going to suggest, should we mark this as Exhibit 3?
Well, this is a oral presentation of the documents that have been submitted already as part of the written submission and affidavit list, the exhibit list for clarification. You can mark this as exhibit.
Or your whole binder as Exhibit 3?
That's right. The binder was submitted in advance, and that is the submissions. This is merely an outline of our oral presentation
No, I
today.
realize that, but should we mark the binder as Exhibit 3?
Yes, you can mark that as Exhibit 3.
Okay, so we'll mark that as Exhibit 3. Okay. So go ahead.
Mr. Mayor, members of the council, we submit that the primary issue for today's hearing is whether or not the operations of Tokyo Beauty in its current state pose a material risk to public safety and thus justify an extreme sanction of full cancellation of its business license in respect of its Aberdeen store. Our client's position can be summarized as follows. Number one, we respectfully submit that the proposed cancellation of its business license is disproportionate and unwarranted, given the company's absence of non-compliance since March of 2024 and its significant compliance efforts to prevent future non-compliance. We respectfully submit that Tokyo Beauty at its current state does not pose a risk to public safety. The incidents of non-compliance, as advised by Health Canada, have been fully rectified and substantial measures have been implemented to prevent recurrence. We respectfully submit that the city's recommendation fails to consider Tokyo Beauty's current compliance status, material improvements, and the broader social, economic, and community impacts that the decision will raise. The city's recommendations are based on out-of-date evidence that fails to conduct its own inspection or investigation. We would also submit that a more proportionate approach, rehabilitation-focused alternatives such as a suspension, probationary conditions on the business license, or compliance audits would be better to balance the need for accountability with the importance of preserving Tokyo Beauty's contributions to Richmond's economy and diverse business landscape. In respect of the factual background, Tokyo Beauty has been a proud member of the Richmond community for many years. They operate 3 retail locations, as said by my friend Mark Corrado. The businesses provides high-quality Japanese products that are difficult to find elsewhere in the region. The offerings cater to a diverse customer base, including local residents, visitors from the local mainland, and even international customers. The Aberdeen store in particular is a vital hub for Tokyo Beauty's operations. It directly employs 12 individuals, many of whom are the sole owners supporting their families. Beyond its employees, Tokyo Beauty works with over 25 local suppliers and service providers, creating a ripple effect of economic contributions to the city. Regrettably, Tokyo Beauty experienced regulatory issues when Health Canada identified prohibited products being sold on a few occasions. These incidents, while regrettable, were isolated. Health Canada issued advisories listing the prohibited products, but did not recommend for the cancellation of Tokyo Beauty's business license. In addition, Health Canada did not recommend or proceed with any means of prosecution against the business. Since these incidents, Tokyo Beauty has taken immediate corrective actions to ensure compliance. The last advisory from Health Canada was issued in March of 2024, and there have been no violations or compliance issues since that time. This period of full compliance, we would submit that it demonstrates the effectiveness of Tokyo Beauty's efforts and its dedication to adhering to the highest regulatory standards. In respect of compliance measures, since the issues were identified by Health Canada, Tokyo Beauty has implemented a robust compliance framework that addresses past concerns and establishes a strong foundation for future operations. These measures were developed with the assistance of legal professionals and are designated and designed to prevent any recurrence of non-compliance. I would like to turn your attention to Exhibit A, the Compliance Policy Manual as referenced in our list of exhibits in our submission materials. You'll find that at tab A of the black binder. Here you'll see that on October 16th, Tokyo Beauty distributed this Compliance Policy Manual, which became effective on November 1st of 2024. The manual outlines comprehensive compliance procedures for product procurement, supplier verification, employee responsibilities, and emergency response protocols, otherwise known as ERP. The manual outlines the comprehensive procedures and provides employees with a clear understanding of Health Canada's standards, tools for identifying non-compliant products, and processes for verifying product compliance through the regulatory databases as recommended by Health Canada. Copies of this manual were distributed to all Tokyo Beauty locations, ensuring consistency across the organization. Turning your attention now to Exhibit B as referenced in our list of exhibits, here you will find the Tokyo Beauty Product Standard Management Document Receipts form. This form is used as confirmation that the Tokyo Beauty store managers have received and reviewed the compliance policies as outlined in the manual. It ensures transparency and accountability and demonstrates that every employee is aware and committed to holding up the company's regulatory obligations. At Exhibit C, you will find Tokyo Beauty's employee training policy. Tokyo Beauty implemented a mandatory training policy to ensure that all employees, store managers included, understand their compliance responsibilities. Existing employees were required to complete training by November 30th, 2024, while any new hires by the business must complete training before their first day of work. The policy ensures that all staff are equipped to uphold the regulatory standards from the outset of their employment, and it sets forth mandatory training requirements for both existing employees and new hires, with a focus on compliance in the cosmetics industry. Turning to Exhibit D, here you'll find a copy of the Tokyo Beauty Product Compliance Supervision and Non-Compliance Penalty Policy. This is a policy implemented by the business as a progressive penalty system to hold store managers accountable in their business operations for compliance violations. A first violation under this policy results in the deduction of a manager's monthly commission. A second violation results in the demotion from their managerial position. And a third violation results in the termination of their managerial role and termination from the employment ultimately. This policy reinforces accountability and ensures that the store managers play an active role in maintaining compliance. In respect of internal auditing, Tokyo Beauty conducts regular internal audits to verify adherence to any compliance standards. Findings from these audits are used to address gaps and continuously improve operations. Turning your attention to Exhibit E, at tab E, you'll find a copy of the Tokyo Beauty non-compliant products list. This list provides a detailed record of all the flagged products identified by Health Canada and the corrective actions taken to address these issues. It also reflects Tokyo Beauty's ongoing efforts to strengthen its inventory management processes, ensuring that all products meet regulatory standards before reaching shelves. In respect of Exhibit F, I would like to turn your attention to Exhibit F, being tab F. This is the Tokyo Beauty Store Compliance Inspection Log. This is an internal log that tracks internal audits conducted at Tokyo Beauty locations. It's used to verify adherence to complier standards. The document demonstrates the company's commitment to self-monitoring and continuous improvement, and it provides tangible evidence of its proactive approach to regulatory compliance. At Exhibit G, tab G, you will find the Tokyo Beauty internal communication regarding non-compliant products. These are communications that document internal discussions and directives aimed at addressing the past non-compliant incidents. They also illustrate Tokyo Beauty's internal commitment to transparency, swift corrective actions, and the prioritization of compliance across all levels of the organization. Another point in respect of supplier oversight, in accordance with the policy manual that was adopted by the business, suppliers are now required to verify product compliance before approval for sale. This means and ensures that non-compliant products will not enter Tokyo Beauty's supply chain. In respect of our ERP, Tokyo Beauty has implemented the emergency response plan to handle compliance-related crises swiftly and effectively, and this includes coordination with regulatory bodies as needed on a case-by-case basis. And moving on in respect of cooperation with regulatory authorities, we would respectfully submit that Tokyo Beauty has made consistent efforts to collaborate with the regulatory authorities involved, including Health Canada and the City of Richmond, to ensure its operations align with all applicable laws and standards. In May of 2024, Tokyo Beauty contacted the City of Richmond to seek guidance on compliance requirements. This demonstrates the company's proactive approach to addressing any municipal concerns. Attached as Exhibit H, you'll find a letter from Legal Counsel of Tokyo Beauty to the City of Richmond dated May 30th. This letter represents Tokyo Beauty's proactive attempt to engage with the city and seek guidance on aligning its operations with the regulatory expectations that it is subject to. Despite not receiving a response, Tokyo Beauty independently developed and implemented its compliance framework, underscoring its good faith effort to collaborate with the city. Despite receiving no response or direction from the city, Tokyo Beauty has also worked closely with Health Canada, voluntarily submitting products for inspection and promptly removing flagged items. This collaboration underscores the company's commitment to transparency and public safety. Attached as Exhibit I, as referenced in our exhibit list, you'll find an attachment that is an email correspondence between the director of Tokyo Beauty and the product safety officer at Health Canada. These email communications reflect Tokyo Beauty's direct engagement with Health Canada to clarify regulations and verify the compliance of its products. They provide evidence of Tokyo Beauty's transparency and its willingness to take extra steps to ensure adherence to regulatory standards. In respect of community involvement and economic contributions, we submit that Tokyo Beauty's position and Tokyo Beauty's operations contribute significantly to Richmond's economic and cultural fabric. In respect of employment, as stated before, the Aberdeen store employs 12 employees. In respect of supporting local businesses, Tokyo Beauty indirectly supports over 25 local suppliers, including importation services, transportation providers, and marketing agencies. the closure of the Aberdeen store could disrupt these partnerships and create a domino effect of economic instability. In addition, in respect of community engagement, Tokyo Beauty actively participates in community initiatives, including donations to nonprofits and sponsorships for cultural events. The company has also been involved in community outreach programs, such as toy drives and the food bank projects, underscoring its commitment to supporting vulnerable members of society. Additionally, it has provided free Japanese rice and tea to single mothers, students, and struggling members of the community, further exemplifying its role as a socially responsible and engaged corporate citizen. Moving on to the lack of inspection and evidence, it's important to highlight that this matter is not about enforcing federal laws or prosecuting past violations under federal legislation. It is also not within the purview of the Council to prosecute under federal legislation. Rather, the focus is on assessing the business's current practices and determining if they pose a legitimate risk to the public at this time. This distinction is critical as it requires decisions to be grounded in present evidence and the realities of the business operations, not in the assumptions or outdated information as proposed. A critical issue that must be addressed is the city's complete lack of recent inspection or investigation into Tokyo Beauty's current operations. We would like to emphasize that the last public advisory issued by Health Canada was in March of 2024, nearly 8 months ago. Since then, neither the city nor Health Canada or any other regulatory authority has identified any further compliance issues. The city has relied on the affidavit of Ms. Lena Ng, an officer at Health Canada, to support its case. However, we submit that this evidence does not provide substantive additional support. The affidavit reiterates the findings of noncompliance that formed the basis of the last public advisory, which the city has already submitted and relied upon. It is merely noted noncompliance identified in February of 2024 without citing any subsequent instances of noncompliance or identifying ongoing concerns regarding Tokyo Beauty. For the sake of procedural fairness and substantive deliberation, we would further submit that it would be beneficial for this hearing to invite a representative from Health Canada to address these issues and respond to the Council's concerns regarding the potential risks to public safety. Importantly, the city has not conducted any follow-up inspections, inquiries, or other such actions during this time to monitor the business practices. This failure to inspect is deeply concerning. It shows that the city has not taken the necessary steps to verify whether the conditions referenced in the advisory still exist. Tokyo Beauty has taken significant steps to address all of the non-compliance issues brought to attention. The city has shown no interest in evaluating these improvements. Instead, the city has based its recommendation for the license cancellation solely on historical incidents. This approach fails to recognize the efforts that Tokyo Beauty has made to rehabilitate and comply with relevant standards. It also disregards the principle of fairness and natural justice that requires that regulatory decision-making must be based on current, accurate, and complete information. Health Canada's silence since March of 2024 is significant. As a federal authority with expertise in monitoring public health risks, the absence of Health Canada's further advisories indicates Tokyo Beauty has resolved the issues earlier raised in the year. This makes the city's inaction even more troubling. If Health Canada sees no reason to issue additional warnings, why has the city not taken any independent inspection to confirm the status of the business operations? By failing to conduct inspections, the city has essentially relied on outdated evidence and speculation in this regard. The lack of due diligence undermines the legitimacy of its recommendation to cancel the business license. Regulatory bodies have an obligation to make decisions based on reliable and up-to-date information, particularly where the stakes are as high as they are now. Without current evidence, the city cannot credibly argue that Tokyo Beauty poses an ongoing and current public safety risk and concern. Finally, the absence of the inspection also highlights a missed opportunity for collaboration. Instead of working with Tokyo Beauty to ensure continued compliance, the city has chosen to recommend the most severe penalty without engaging with the business or verifying the current state of operations. This adversarial approach does nothing to support the public safety or encourage businesses to improve. It merely punishes without consideration of progress or rehabilitation or the current efforts and compliance efforts that Tokyo Beauty has implemented within its operations. For these reasons, we would urge Council to recognize the flaws in the city's process and consider a more balanced and evidence-based approach in addressing this matter. In respect of proportionality and fairness, the principle of proportionality is essential to fair administrative decision-making. Proportionality requires that any sanction should be appropriate to the nature and severity of the harm caused. In this case, the recommendation for license cancellation is entirely disproportionate to the circumstances and fails to consider the substantial progress that Tokyo Beauty has made. Looking at the facts, the Aberdeen store has 2 historical violations on its record. It is critical to note that there have been no further incidents, and no incidents have been reported since these violations have occurred. Furthermore, Health Canada, the highly regarded public authority in public health regulation, has not issued any additional advisories or found compliance issues in the past 8 months. This absence of recent violations demonstrates that the business has taken meaningful steps to address the concerns raised in the past. The recommendation to cancel the business license entirely overlooks these efforts. Tokyo Beauty has demonstrated a clear commitment to compliance and has implemented measures to improve its practices. The city does not prove that, but for a full cancellation of the Aberdeen store business license, there will be an ongoing and substantial risk to public safety. Imposing the harshest potential penalty in response to historical violations without any evidence of ongoing harm is both unfair and excessive. It is important to consider the broader applications of such a decision. License cancellation is a punitive measure that effectively shuts down a business, depriving it of the opportunity to correct its past practices and contribute to the community. The approach is not only harsh, but it is counterproductive to the landscape in Richmond. Businesses that are willing to engage in corrective action and comply with the regulations should be given the chance to do so. In this case, Tokyo Beauty has shown willingness to improve, and it is in the public's interest to encourage this type of behavior and progress rather than to impose an irreversible sanction. To that end, Tokyo Beauty respectfully submits that the council consider alternative sanctions that are better aligned with the principles of fairness, natural justice, and proportionality. These alternatives would ensure public safety while allowing the business to continue its efforts to comply with the regulations. I will outline several specific options for your consideration. In the alternative of business license cancellation, a suspension with conditions may be warranted. A temporary suspension of the business license would serve as a clear warning and give Tokyo Beauty the opportunity to demonstrate its commitment to compliance. During the suspension period, the business could be required to implement specific corrective measures, such as enhanced staff training, stricter quality control protocols, and improved documentation practices. This approach would better balance the accountability with the chance of improvement. In the alternative, we respectfully suggest a probationary period. Another option is to place Tokyo Beauty on probation for a specified period of time, during which its operations would be subject to strict oversight. Any further violations regarding that appear or arise during this probationary period could trigger other penalties, such as an extended suspension. This option provides an incentive for the business to maintain compliance while ensuring that any future risks are closely monitored. In the alternative, we would request mandatory compliance reporting. The council may require Tokyo Beauty to submit quarterly compliance reports to the city with regular updates on the business's progress. These reports could include details on staff training sessions, product audits, and any other compliance-related activities. This approach ensures transparency and allows the city to monitor the business's efforts without resorting to punitive measures. In the alternative, in respect of independent compliance audits, the council may mandate a third-party audit to be another effective alternative. An independent auditor could verify that Tokyo Beauty is adhering to all relevant rules and regulations and provide an objective assessment of the business's practices. These audits would not only ensure compliance, but it would also build trust between the business and appropriate regulatory authorities. In the alternative, the council could consider a more collaborative approach by partnering with Tokyo Beauty to improve compliance. This could involve conducting joint workshops, providing guidance on best practices, and establishing a schedule for regular inspections. Such a partnership could foster a cooperative relationship and help Tokyo Beauty achieve a period of sustained compliance and compliance in the long term. These alternatives offer a more balanced and constructive approach to addressing the situation. They ensure that the public safety remains as a top priority while giving the business an opportunity to demonstrate its commitment to improvement. Importantly, they reflect the principle of proportionality by tailoring the response to the nature of the violations and the progress Tokyo Beauty has made. I'll now pass it off to my colleague Lawrence Hung to reiterate our conclusion on this matter.
All right, so Mr. Mayor and councilors, in conclusion, Tokyo Beauty has demonstrated its commitment to regulatory compliance through proactive corrective measures, ongoing cooperation with the authorities, and the implementation of the robust compliance measures you saw in the binder. The company has taken responsibility and has implemented long-term solutions to ensure adherence to all applicable regulations affecting their business. The proposed license cancellation would be a disproportionate response that harms not only the business, but the employees, the suppliers, the broader community of the city of Richmond, just the landscape in general. Our position is that the city's recommendation to cancel the business license for the Aberdeen store disregards Tokyo Beauty's substantial progress. The city fails to conduct inspections to confirm the current practices of Tokyo Beauty, and it's not proportionate to the conduct of Tokyo Beauty. Overall, the city's recommendations fail to consider the totality of the circumstances. We respectfully urge the council to reject the recommendation for license cancellation and adopt a proportionate rehabilitation-oriented approach. We thank you for your time and your attention, and we're ready to answer any questions and concerns you may have.
Okay. Thank you. We have a few questions. Councillor Liu.
Thank you for your presentation. You mentioned that, our staff should come out and do field trips and workshops and collaborate. How much is a business license in Richmond? And for that price, do you think our staff should be coming out and visiting all 17,000 businesses in Richmond and giving them essentially what you're asking for is like an educational assistant to nurse them along to be compliant? You've said that your client has been compliant. So help me understand how getting caught with the exact same product over and over again on your shelf is compliance.
All right, let's have their answer.
So just to clarify, in respect of the city's involvement and independent investigation into the matter, it's when, as an administrative decision maker, it's our position that if council is going to impose a penalty, essentially, on the business, a severe, harsh consequence being the cancellation of its business license, there must have been steps by the city to have gone to these Tokyo Beauty locations and have thus ensured that there is no ongoing non-compliance issues that are up to date and current. As of the date the Health Canada advisories were published and our client became aware of that, they have taken all steps necessary to rectify any and all non-compliance violations in respect of those instances. So when the city council is proposing to cancel the business license rather than suspend the business license, it is on the city to also ensure that there is still an ongoing public risk. It's not possible to say that there is an ongoing public risk when there have been no investigations done at this time.
Well, I don't think that we actually have to prove that there's an ongoing risk. I think the point is they were suspended in November and they got caught again with their hand in the cookie jar screwing up. So 3 strikes, you're out.
All right, yeah. Okay, Councillor Heath.
Yeah, yes, Your Mayor. Thank you. I'm almost having a deja vu here in front of a defense counsel trying to defend a chronic offender and have them released out of jail. At least we're dealing with an individual, and you use the term rehabilitation. Well, I've never heard it used rehabilitation in business. I've got it. I just want to lay the context here. You mentioned that if we shut it down, there's a risk to the public. What is that risk?
I mentioned that shutting the business down is disproportionate in respect of the
You said
harm and
risk to
caused.
public safety.
That's right. There's no longer a risk to public safety, seeing that Tokyo Beauty has taken significant steps to implement its policies in terms of its employee training policy, the penalty policy, the compliance handbook, the policy products manual, and all of the training sessions that it has taken. The steps at this state do not constitute, considering the totality of the circumstances, a significant risk to the public at this time.
Okay, so if we shut it down, there's a risk to public safety.
I feel like you misunderstood what we were
I
saying.
think you misstated it.
We were saying that there is no current risk to public safety, so there should be no reason to shut down the
Okay.
store. Yes.
Let's go on. You seem to blame council and the city of Richmond for the lack of having a responsible business here in Richmond. We give business licenses to responsible businesses. That's our function here as a city. So when you accuse the fact that we have need to do inspections to ensure compliance. No, as Councillor Liu said, 17,000 business.
This is
I'm
for
get-
questions.
That's fine, I'm getting to that.
Please.
So when you say that we need to check for compliance, you say we're outdated information. This only happened in March of 2024, 8 months, and you're saying it's outdated information. I have difficulty understanding that. And my question is, you say you're an economic driver here in Richmond. How much do you pay your employees?
We'd like to first respond to the entirety of your question.
Well, then respond.
In respect of his submissions, we would urge council that, and clarify with council that we are not blaming council for not addressing the particular issue of going to these Tokyo Beauty locations to ascertain whether or not there have been current violations. In respect of outdated information, the public advisories and the reliance on the March 2024 public advisories by the report as submitted by Mark Corrado have taken place as of March. Our point is that since March up until the current date, in consideration of putting in such a punitive penalty, there has been absolutely no confirmation that our client is currently posing a risk to public safety. After the type of the notice, they complied with full effect, and ever since May, they have been developing this policy manual and have been improving its compliance procedures.
All right. Councillor Wolf.
Thank you, Your Worship. Just a couple of the same questions asked our staff, and you might be more suited to answer. Would you consider the Westminster Highway store the main store in Richmond of the three?
Tokyo Beauty operates 3 stores in Richmond. It would be improper to designate one as the main store.
Thanks. Follow-up question, are the same products sold in all 3 stores in Richmond?
No, the same products are not sold in all 3 stores.
Could you clarify how that is the case? Is one store solely creams and one not creams? Like, what's the difference there?
So the store managers will have some leeway to choose and pick which sorts of products they want to carry in their stores. So not necessarily every store will carry the exact same things.
Thanks. And then follow up on that, do store managers work at just one of the store locations, or do they work at multiple stores?
Just the one, I believe.
Okay. And then my final question, in your tab D, under store manager accountability and penalty system, your first violation is deduction of commission. Your second violation is the pause of the manager position, and the third violation is the termination of the position. So my question is, what if that store manager has a willingness to improve and would like to go through a rehabilitation program? Would they still be terminated because they had the third violation?
If there is a third violation, the manager would be terminated. And in respect of the supervision policy and the penalty policy, we are open to, of course, suggestions by the City and Health Canada to rectify that as such.
Councillor McNulty.
Yeah, thank you very much. Thank you very much for your presentation. I'd like to ask some questions, being a layperson and not having the legal acumen that you gentlemen have. But I would let you know that a business license is $150. And we're going to look after 70,000 people for $150. And thank you for your presentation. This paper, by the way, from my perspective, Your Worship, the question is,
We can make comments,
All right.
just questions at this point.
would you admit that for 5 years, this organization has violated a number of acts now that you know them, the Health Act and the city's bylaws? Would you admit that?
Our client is not contesting the fact that they have had these health violations in the past, right? It's simply,
But you haven't admitted it, that they have. They have had nine.
They're not contesting it. So
You're not,
we can-
well, they haven't admitted it either, Your
It
Worship.
doesn't matter. They-
Well, from my point of view, it
Unless
does.
they contest it, it's
Okay.
admitted.
All right. As far as I'm concerned, you haven't admitted it. You've blamed the city. And which I really take exception to, but I want to give you a fair hearing because I'm a pro-business person here. Unfortunately, you wrote in your document, you're going to allow a district manager or whatever to make 3 mistakes. It says right here. 1, 2, and 3. Thank you, Councillor Wolf, for asking the question. 1, 2, and 3. To me, you've already made one mistake. You got caught in the newspaper. So I guess that, how are you going to handle that now? If you've got one product, and it's not our job to go over and get it, but let's say Health Canada does it. You talk about public safety. You've been selling products for 5 years that are violated by public safety according to Health Canada. You're going to let him go 1, 2, and 3? Explain that to me. How are you going to handle that?
No, so to clarify in respect of the supervision policy, our client is open, of course, to adjust the policy depending on the circumstances at hand. Seeing that from March of 2024, when these health advisories were published and the findings therein, there have been significant measures that have been taken on behalf of the business, by the business. To reiterate, considering these significant efforts, having this policy is still open to further adjustment depending on the needs of the city as well as Health Canada. At the end of the day, the business is looking to collaborate and is seeking to get better. At the end of the day, they're not disregarding any of the regrettable mistakes and issues that happened in the past. They're seeking to get better and have employed significant compliance materials in order to comply with all appropriate laws and regulations, be it the BC Cosmetics regulation, be it federal laws, be it municipal bylaw regulations, any and all regulations, they're willing and seeking to cooperate with.
Okay, well, last question. And I haven't been to the store, but in the store, are there signs up indicating what products are for and what potential hazards will be for taking that product, whether it's an eye drop, if you have such and such, don't take this one, take this one? Is that part and parcel of the safety aspect for the consumer?
In respect of ongoing safety, the business will not sell any prohibited products or any products that contain prohibited ingredients as of the time these measures have been implemented.
Okay. Thank you. I'll make comments later.
Thank you, Your Worship. Thank you. I just have one question. Is the store manager the importer of products directly from overseas? So if they decide they want certain products, they're the ones importing them?
So, Lawrence, go ahead.
So basically, Tokyo Beauty collaborates with like a company in Japan. So there's basically like a big list of products that they could import. And then essentially the store managers will sort of pick and choose which ones they would prefer to have in their stores. And that's how they would essentially tailor their product list.
And then they order them directly from Japan, or does Nagoya Trading as
No,
a
it's
whole
Nagoya
bring
Trading.
things
Yes.
over? That all the managers have access to products that Nagoya Trading brought over?
Yes, they would all be able to.
Thank you.
All right, we'll have a quick question from Councillor Day online.
Thank you very much. Everybody can hear me okay?
Yes?
Good, thank you. So your company has sold products that according to Health Canada can contribute to drug addiction and blindness. In the case that someone had these adverse effects, what would your position be as a company for this customer?
Do you know?
We wouldn't be able to speak to that.
All right. Councillor Liu.
Just one more question. Thank you. So if I look at the health advisory on November the 8th of 2024, it talks about the original advisory came September 18th, 2023, because things were being sold at the 8191 Westminster Highway. It almost seems like we shut them down for 2 months, and all those products were found again over on Hazel Bridge. So it's not even like you threw them out and started over, you just moved them around Richmond.
Is that so?
Is that what happened?
No. So Tokyo Beauty has implemented across all its locations, these compliance policies. So before, the business operations are in respect of course, the 3 locations, but as we said before, the procurement of products is independent to an extent. It's independent by way of the store managers and based on the needs of each store, right? And in that internal communication between them and the business to then order products accordingly. But in respect of the significant compliance measures that they've taken, these address and are streamlined to address compliance for every single store as of March 2024.
Because I would have almost thought you had those extra employees that weren't working in the Westminster Highway
This is
store. They
for
could have gone over
questions.
and helped remove these ones from the shelves over in Aberdeen. So they didn't do that. They didn't help.
Well, the
Ameliorate.
employees at a certain store are not the same employees at the other store, if that's what you're
Thank you.
suggesting.
Okay, thank you, gentlemen. Thank you. I'll ask Mr. Corrado and Mr. Howson, please, we'll excuse you. You're excused. All right, is there anything you want to add to what you've told us? I think we've got a pretty clear picture of the situation.
To your worship, I have nothing further to add.
Okay,
I really have nothing further to add.
Okay.
I think the council has zeroed in on
okay.
the
My
issues.
question is, comment has been made about a delay since March. Why has there been a delay?
Through your worship, to your worship, the delay was in staff meeting with Health Canada and determining investigative deconfliction, determining if there were any other investigations going on, trying to get to the bottom of what specific violations were at play, getting a hold of the inspectors themselves and understanding their process, and most importantly, getting a word from Health Canada that it's the city's responsibility to take action against the license. And that's the key point for deconfliction. We didn't want to step on their toes if they were going to remove the license.
Is it the policy or the procedure or the responsibility of the city to actually go out and inspect these, various retail operations to make sure that there's compliance?
That's a good point, and I think that one of the submissions that was made by council for the licensee conflates the role of the city and the license inspectors with the role of the inspectors from Health Canada. We don't go up and do follow-up inspections on their roles. And with respect to any delay and the comments of counsel for the licensee with respect to, this all happened back in March. One would easily, if we rushed to judgment on this and brought the cancellation hearing any faster without a thorough inspection and a thorough exchange with Health Canada, we could also be criticized for not doing a complete job. In the context of this hearing and the proposal to cancel the license, this whole matter crystallized in March. That is to say that you have to focus somewhere on something, and March isn't that long ago. I'll just editorialize a little bit, and one of the councilors focused on this, and I think it's legitimate. How does a product containing an opioid?
Listen, we're just getting your comments now. We're not
Okay.
into submissions.
Anyway, in any
To your
event.
worship, just sorry to interject too, because it's this complex case of the complex timeline. I should add there were actual inspections done by staff at the Westminster location. And in those were in regards to violations of the sign bylaw and the requirement to get ongoing plumbing permits. That's what delayed the implementation of the awarding of the license for the Westminster location. So there was actually on-site staff visits.
Yeah.
Well, also, a subpoena was issued to Health Canada, which eventually resulted in the affidavit.
To your worship, that's correct.
Okay, and what about the criticism that's been leveled that the city is not working with with this company? Is that so? Is that the role of the city?
To your worship, in the matters I just referenced in Westminster, the city worked with the business to get them into compliance with our sign bylaw to get their license up and going. Post-March, however, once there was this investigation that was ongoing, typically staff do not work with subjects that are under investigation. They investigate them. Secondly, as I alluded to before with that enhanced security clearance, when we open up dialogue with another law enforcement agency, that's predicated on the assumption that I am not going to share any information with the subject of that investigation. Staff needed to corroborate the allegations that were in the media, and most importantly, understand if there were additional targets of that investigation. I should also note that one of the allegations, and it's been found that they were selling a Schedule I CDSA-related drug. This could have law enforcement implications to it as well. So typically during an investigation, until the conclusion of that investigation, staff do not work with a business regarding the contents of that investigation. However, we did work with the business regarding other regulatory matters.
All right. All right. Anything further?
Nothing further add, Your Worship.
I should ask the other folks from Tokyo Beauty, do you have any other people you want to talk to us?
Nothing further.
Nothing further. Okay, thank you. We will excuse staff. You have the staff recommendation. Someone can make a motion or an alternative motion. So the recommendation has been moved and seconded. I've got so many papers here. So let's just remember what that is. Cancel the business license at this unit on Hazelbridge, adopting the reasons that are set out in Exhibit 1, and if we wish, we can issue supplemental written reasons at a later date. So that has been moved and seconded. We'll go to Councillor Heed.
Yes, I'm going to be short because I'm sure other councillors would like to comment on this, but I'll tell you, if I had my way, I'd be pulling all 3 licenses out of Richmond and get them out of here. The opioid addiction is incredibly, and this is my main concern, incredible for us. We know the havoc we went through the beginning of February in 2024 with the people demonstrating here. I find out it was later that month, there was a violation in one of the offices. I believe it was the 26th of February. I may be wrong. But however, if we look at the problem, the crisis, not only related to the opioids, and you look at the prescription ones that were given out, especially in the United States, the OxyContin movement, the lawsuits with respect to that in the United States and one here in Canada, I'll tell you, we have to have a deterrent in effect. And, certainly and I understand that they want to continue operating here in Richmond, but boy, I think they're fortunate that we're just going after the Aberdeen Centre one. We're not going after the other 2 licenses here. So certainly, I'm very much in support of staff's recommendation. I want to thank, the staff for coming forward. I want to thank Mr. Hassan, our council, for bringing this matter and providing the information. But I strongly support this recommendation that the license is suspended. Thank you.
Councillor McNulty?
Yeah, thanks very much. I'm going to say a little bit more. I will support the suspension.
Cancellation.
The cancellation of the, due. I was, to be honest with you, I was not very comfortable with the defense. Basic was a blame of the city and the fact that we didn't do our job and our staff didn't do a job. And I want to say our staff did a hell of a job. Thank you very much. Yeah, couldn't have done a better job. I just wasn't, I'm not comfortable with the organization, what I've heard with the defense, the attitude of the client, taking responsibility and admission. And I agree with, I have opioids are drugs. And you know the attitude towards drugs in this committee, and community safety is paramount. And just because it's on the shelf, without a description that people are taking, it doesn't mean to say it's good. So I think we have to, in this case, we deal with the one place, but there are two other stores. And I'm sure we'll be watching and seeing what's happening there as well. But our defense was saying 8 months doesn't wipe out 5 years of violations. You don't want to be rewarded because I've been good boy for 3 years, so we've had 5 years, we've had other suspensions, we've said you can't do this, you can't do that. We've had an organization that's responsible in the country to enforce the laws, violated as well, and had to come along. So I don't know how much you've got to do, and we're talking removal of one business license. When we talk about, like I said, in particular the opiates, I'm very concerned with the public safety and people. They've had consultation, was admitted that there's consultation. I don't know what kind, but it's something that I really think when we contravene the acts of Canada for products and the acts in the community, I think we have to take a stand. I think the city needs to do what it can to protect the citizens. And so I'm going to support the staff recommendation. And I know others are going to say the same kind of thing. And we need to be watching for this kind of thing, not only here, but in all our businesses and all our 1,400 businesses in the city, Your Worship, and I'm sure we will be doing so. So to staff, thank you very much.
14,000 there, Councillor.
Didn't I say 1,000?
No, you said 100.
Oh, apologies, add a zero.
What's a zero?
Add a zero.
Councillor Galanders.
Thank you, Your Worship. I agree with the comments from the other councillors. This is a very serious matter. I was also uncomfortable with a lot of the presentation from the defense, just minimizing the seriousness of the allegations. What I see is that, last year, it was a really, really big deal to suspend that business license. There was a lot of, opposition to it, not a lot, but, just pleading, with us to not be take it so far before the Christmas season, and that it would harm the business and the employees. And that was a big deal. That's a big warning. And then within 4 or 5 months to have the same products show up at the stores again just shows a real lack of regard for and seriousness. The suspension didn't serve its purpose. It didn't keep the city safe. Consumers were still had these very dangerous products available to them. And so absolutely cancellation of the license is warranted. And what I see in the, what was called extraordinary measures taken by the company to change their ways, what I see in there is a lot of employee compliance, expecting employees to be aware of all different products that are prohibited, and for the employees to know, to look out for them, that there was a manager inspection done on a couple of weeks ago. So it looks like in response to all of this, there's been a couple of steps added. But when an employee works at London Drugs, is it their responsibility to know every single product that's on the shelves and if they're prohibited or not? And is it the employee's responsibility at a Canadian drugstore to point out if there's products on the shelves that aren't legal? No, it's the company that's bringing the products in that is the problem. There's a company that's importing opioid cold medication and having it available to purchase on the shelves. And the employees, it's not their responsibility. This goes much higher than that. And if this sends Nagoya Trading a message that they need to stop importing illegal products and putting them on the shelves at various stores throughout Richmond, then that's absolutely what we need to do. As Councillor Heed said, you know, the cause of the opioid crisis that we're in, which is the leading killer of men aged 18 to 35 now in this country, tens and thousands of deaths in this province alone. And it was caused by overprescribing opioid medication, what people thought was simple pain relief, you know, and they got hooked on it. And then when they wouldn't get their prescriptions anymore, they seeked something stronger. And this is continuing that cycle, having these products available. It's very dangerous. And just one last comment. I agree with, you know, the comments from council about how much effort our staff has already had to go through, you know, how much cost and expense and resources that it's taking to deal with this business license. Just the amount of, you know, binders and everything alone that's had to be put together to make this happen, to expect our staff to have to do more proactive working with the company is just beyond me. I think they've done more than enough and that this is absolutely warranted. And now we'll only have 2 stores instead of 3 to spend our time and resources inspecting. So it's very generous in my opinion.
Councillor Liu.
Yeah, thank you, Your Worship. Thank you to staff for your thorough and fair process that you followed and a very comprehensive report that you gave us. It seems to me that last year when we were looking at this, one of the other items that was on the list that had been found was hydroquinone, was a product with hydroquinone on it. And I don't see that on the current list that they're saying, recommending to their own staff to make sure is not on there. It's not our job to audit products on shelves, but when egregious transgressions are brought to light, we really can't knowingly issue a business license and lend that company any validation. And I think if as much effort had been taken to pull that handful of items off those shelves, as was put into this presentation right now, they would have been in compliance. But it's not as if the products that resurfaced in March were either under a new name or new packaging. There's no reasonable argument that they're still on any shelves in this company. They know that they're there. They know that they've been bringing in steroids, narcotics, and other controlled drugs. It's not okay. They're controlled for a reason because they have negative side effects. The reason they work is because they have effects. Well, if they have effects, they also have side effects, and that's why all these drugs are controlled. So I support what we're doing here, and I have a feeling that the people that came and presented and asked for more oversight from our staff in their stores, they're probably going to get that.
Councillor Wolf.
Thank you. Yeah, so I just reading one of the letters again from a regular shopper at the store, telling us before we make a decision tonight that we should let women buy what they want, that the business is not a threat to society or safety, that people ask friends and family traveling to Japan to bring these products back for them. What we can decide tonight is in regards to a business license of a business operating in Richmond. We can't decide what people do the rest of the time. I would also just like to echo some of the sentiment around the table on the severity of this and the potential freedom to have 2 more stores still operating in Richmond. I value the defendant's package and all the changes that will be put into place for these remaining 2 stores. The one thing I would just suggest that going forward, if there's another first violation, I would probably expect that to result in termination of that position because it's very likely that the cancellation of the other 2 business licenses will follow. Thank you.
All right, we're going online. We've got Councillor Hobbs. Councillor Hobbs, are you there?
Yep.
Okay.
I just unmuted. You can hear me okay?
Yeah, and we are trying to get through this. We've got still a long agenda. Go ahead.
All right, thanks. Yeah, I'll be quick. First of all, thanks to staff for a very comprehensive and thorough report and investigation. I appreciated the comments. And likewise with the delegates, they were thorough. The reality is, at all levels of government, we rely on the voluntary compliance and the vast number of regulations and laws. As has been mentioned, we have over 14,000 businesses in Richmond. It's impossible to act proactively with respect to various violations for businesses. The primary consideration for me, and it's been mentioned by other people, is the seriousness and the potential harm to the public with what we're talking about tonight. So the corrective action that the delegates mentioned in relation to the stores, that is good work. And I think that that should be continued on at the locations that you have. But for me, the seriousness and the potential harm to the public and to public safety must be our priority consideration. And so I'll be supporting staff's recommendation. Thank you.
All right, Councillor Day.
Thank you very much, Mayor Brody. This is a horrific situation, and I thank Health Canada and I thank our staff for working together because they have done an outstanding job to clean this up and take care of this one problem. There'll be many more in the future. What we don't know is how many people developed a drug problem because of these products. How many people developed eye problems because of these products? And that's the real sadness for me, is that silent group of people that don't even know what happened to them. So you better believe I'm going to support this motion because we simply cannot allow a company to disregard the health of the citizens of Richmond, especially when council has done everything we can to stop the flow of drugs in Richmond and to help the people of Richmond. So thank you very much for staff and Health Canada.
I'll simply add, thank you. I'll simply add to that. I agree with all the comments that have been made by the councillors. And particularly, I agree with the comment that I think that Tokyo Beauty is lucky that staff are not asking for the cancellation of the entire license for all 3 locations. And I hope that they take that comment very seriously. So with that, I'm going to call the question on the motion. All those in favor? Any opposed? That is carried. I take it that Councillor Day and Councillor Hobbs are also in favor from their comments. Yes, we are now, we're now adjourned. And we're going to go back into the closed meeting. So I'll ask